Well, joining us via Zoom now is Nthabiseng Dubazana, who's a director and an attorney at Dubazana Attorneys, to unpack this for us a little bit. Thanks so much indeed for joining us. Welcome to the program.
Thank you so much for having me, Peter.
All right, 20 years in the making. I suppose a lot of people would have been surprised if it had actually started today.
I think so. But I suppose when the day started yesterday, we already had an incline that, there's perhaps going to be a postponement after, in the media, it was announced that there's going to be a private prosecution application. And then in the early hours of this morning, at least I became aware of the fact that there's going to be an application for postponement. I did not know the depth of it until I actually watched the matter this afternoon. In the morning, to realize that, okay, now we are taking it a little bit further and continuing on the right path, I suppose, in trying to, defend your client to the best of your ability. So it would have been very interesting had it started, because we were already expecting that some kind of postponement was already inevitable.
All right, help us understand what's at play here. So, former President Jacob Zuma and his legal team said that the prosecutor, Billy Downer, advocate Billy Downer, can't prosecute him because it would prejudice his case. On what basis have they said that?
So when we look back to the application last year, October, I believe it was, where the defense attorneys for President Zuma made an application in terms of section 106(1)H, wherein they were saying that advocate Billy Downer lacked locus standi to proceed on the matter. They hinted at the fact that when this matter was still in the investigative stages and the matter was not ripe for prosecution at the time, when the matter was not put on the roll, Billy Downer would cry as a result of the matter not being on the roll, Billy Downer having leaked certain information that was supposedly private pertaining to President Zuma's medical records or stuff like that. So by venturing into those aspects that happened over a period of time, they were submitting to the court that it shows that Billy Downer no longer has objectivity to proceed with this matter and already has a perceived bias against President Zuma, and therefore, in their opinion, there will not be a proper service of justice on President Zuma if this matter were to proceed with Billy Downer as the lead prosecutor. So that is the basis of their application last year when this happened. And then Judge Kuhn ruled on it and said that based on the evidence that was put before him, there's not sufficient merit to deem Billy Downer to lack locus standi to proceed with this matter. Now, at this stage, the trial had already started. So the trial starts at the stage whereby you plead. When you plead not guilty, at that moment, the trial has officially started, even though evidence has not been led. So technically speaking, the trial has been part heard since last year, October. And then President Zuma's legal team then invoked a different form of appeal, whereby they required that the decision, the judgment pertaining to section 106(1)H application be reviewed or appealed, I beg your pardon, in the Supreme Court of Appeal. Now, usually what happens in criminal proceedings, you appeal a matter once the trial is concluded. And these are the reasons why the state was of the opinion that it is not ripe for appeal in the SCA. And then they were vindicated when the SCA, the two judges, decided that yes, indeed, the matter is not right for it to be heard on appeal. Hence, we are here where we are today, where President Zuma and his legal team are now petitioning the president of the SCA, Mayor Maya, to then relook or reconsider the judgment or the decision that was made by her colleagues about a week ago pertaining to Billy Downer being removed as a lead prosecutor.
All right. So, what is the likelihood of a Supreme Court saying we made a decision, but now that you've come back, we're going to reconsider it and actually hear it? What is the likelihood of them changing their decision?
If anything, when it comes to the matters pertaining to Ndate Zuma, it's been, like Judge Kun said today, most of the time he hasn't been successful in his applications. I'm of the opinion that the matter was ventilated in the quota quo, which is when he made his first application in October last year, and it was further ventilated in the SCA application of appeal earlier this month. And as a result, I wonder if the president, Memaya, would change the decision that was made by her colleagues. Because like I said, it is, the norm is that once a criminal trial has started, the option and the application of appeal process would start once the trial has concluded. So if they decide, let's say, for example, Memaya decides that, Ndate Zuma does have a case and a leg to stand on, it would mean that in terms of Section 106(1)H, it would mean that the trial in itself will fall away. It would be almost similar to an application in terms of Section 174 of the Criminal Procedure Act, whereby Ndate Zuma cannot, and his co-accused, of course, cannot be tried again for this matter as a result of the prosecution having lacking locus standi and the matter having already been part heard. That would be the smart part of it if this matter were to go in the direction that Ndate Zuma and his legal team wanted to go. However, if it were to be that when Memaya looks at the papers and decides that, let's stick to what is the norm in terms of criminal procedure, and then let the trial proceed, and then at the end all these avenues are still available to you, and then we can have a look at the decision in its entirety, including the 106(1)H, as well as the decision if you happen to be found guilty in this matter at the end of it.
All right, I'm not a lawyer, but it sounds as if we're sort of putting the cart before the horse, because you're saying to someone, you are not independent and impartial, but you haven't given him an opportunity to be lacking in those qualities. And also, he's just one side of the case. There's a whole defense that can protect their client, and a whole judge that can say, hang on, Mr. Dana, you're out of bounds, you can't do this, you can't do that. So it seems as if there's enough checks and balances going into the trial to make sure that everything runs properly. Is there a real argument in trying to remove Dana?
Well, I don't know about real argument, but I believe it's perceived argument on the side of Ndate Zuma and his legal team, based on everything that they put forth when they made their application last year already. So if the presiding officers that hear these arguments agree with them, then it works out great for the accused and his legal team. However, if they disagree with them, then we continue with the trial until its entirety or its conclusion, and then we'll see how it goes from there. So in any event, like we said in the beginning, he has all these legal avenues available to him, and he has all the right in the world to exercise them until he has nothing else left but to continue with the trial. It's not a matter of abusing the system, it's a matter of making sure that you would have tried everything. At least that's what I would do as his defense attorney, to try every avenue that is available to me that I am aware of, or that I can research on, and that I know could possibly help my client. Use it until there's nothing left for me to use, and then I have no other choice but to proceed with the way of trial. So I think with the perception that they have based on the things that they laid in terms of their application in the beginning, they believe that they have a strong case in order for Ndate Dana to be removed as lead prosecutor.
All right, and I guess I'm coming back to the same question, but isn't a case judged on evidence? And this evidence will be presented. It doesn't matter whether it's Downer or someone else presenting it, the evidence will remain the same. And the judge will then decide whether this means this person is guilty or not guilty. Is that not really...
In as much...
Yeah, carry on.
Sorry about that. I was gonna say, in as much as that is true, that it is based on evidence, the prosecutor has to have such objectivity that it doesn't seem that they are biased against the accused. So even though you know you are for the complainant or for the state, you need to ask questions and behave in such a manner that doesn't show any bias on your part. That's why there is a position sometimes, if it happens that an accused person or even a witness in a trial, in normal criminal trials, if the prosecutor is known or has some kind of affiliation in one form or another, or some kind of bias in a matter, they always recuse themselves so that they don't act, so that they can act impartial in the matter. So they rather have somebody who's neutral to the case. So what the defense team is saying is that because Billy Downer has been handling this matter for plus minus 20 years, he now lacks impartiality because he's taken it as an emotional, or he's emotionally vested in the case. So he will not be able to ask questions with a clear mind and get the answers that are required in this case. And each case being judged on its own merits also includes the behaviors of the officers of the court, which include the prosecutor, the defense attorneys, and as well as the presiding officer.
All right, so then stage left, we've got this private prosecution. What's all that about? I mean, that on its own can't stop the trial or delay it. That's a separate matter in its entirety, I'm guessing.
Yes, I was actually of the opinion before I learned this morning that the application for postponement was to allow perhaps the defense team to start with the process of applying for private prosecution. Remember that Zuma went to go open criminal charges against Billy Downer, and then the DPP did not continue with that criminal prosecution. Now, in terms of Section 7 of the Criminal Procedure Act, you can initiate private prosecution once the DPP has issued a nolle prosequi certificate. So by virtue of them having not proceeded with the matter when criminal charges were laid against Billy Downer, it will be now up to the defense attorneys of President Zuma to now approach the DPP and say that, okay, since you are not proceeding with the criminal charges that we laid, then give us a certificate that is written that alleges that you are not proceeding with this matter, which is nolle prosequi, and then they can then proceed in that manner in private prosecution against Billy Downer. And then it will, if it so happens that the criminal trial, I beg your pardon, the criminal charges against that Downer proceed, I'm not sure if it can be then he will be deemed to be impartial to continue to prosecute the accused in this main trial of the arms deal versus him being an accused in the other matter.
All right, we've run out of time, but if you can answer this in less than 30 seconds, that would be great. So I suppose at the crux of this is whether former President Jacob Zuma is either exercising all of his rights to the fullest degree. At what point could it possibly be deemed to be abusing the court, the Stalingrad thing that they talk about? And it seems as if the judge is saying, I don't have enough evidence to prove that this might be the case, and that he even suggested maybe you guys need to go to Parliament and change legislation so that we don't have situations like this.
Yes, in criminal proceedings, unfortunately, it is not on a balance of probabilities as in civil procedure. So it has to be beyond a reasonable doubt. So the judge can only work on what is in front of him as evidence. So in this instance, it is going to be a little bit difficult for the state to prove that Zuma is abusing the system. Whereas in civil proceedings, it's a lot more easier. In fact, there's actually a recent case law that actually showed that a person can be found guilty of abusing the legal system and be penalized for it. In criminal matters, you don't even get court orders. So it'll be a little bit of a stretch to take it there. That's why I think the judge was like, let us get Parliament to change the statutes and the laws to encompass such things.
Nthabiseng, thank you so much. Grateful for that explanation of what's been happening for the last 20 years. Thank you.
Thank you for having me.
All right, that's attorney and director at Dubazana Attorneys, Nthabiseng Dubazana, explaining to us what happened in court today and why this case continues to go through this sort of proper trial process. And so it's sitting at the Supreme Court of Appeal once again, and there's been a request for reconsideration, and the Supreme Court President will have to make a decision, and then things will move forward. And we wait to see. May, I think, is when this matter will next be heard.